I am Professor Kotangle. I am a professor in Government Law College teaching Constitution. I am a professor in Siddhartha College also. I would like to speak about Constitution of India. The introduction of the Constitution of India. The Constitution of India is a supreme law of India. India, also known as a Bharat, is a union of states. It is a sovereign, socialist, secular, democratic republic with parliamentary system of government. The republic is governed in terms of Constitution of India, which was adopted by Constituent Assembly on 26 November 1949 and came into force on 26 January 1950. The Constitution provides for a parliamentary form of government, which is federal in structure with certain unitary features. The constitutional head of the executive of the Union is the President. As per Article 79 of the Constitution of India, the Council of the Parliament of the Union consists of the President and two houses known as Council of the States, that is Rajya Sabha, and House of the People, that is Lok Sabha. The Constitution of India was adopted on 26 November in the year 1949. However, it came into effect on 26 January 1950. 26 January 1950 is celebrated as a Republic Day. It was adopted by the Constitution Assembly. Dr. Babasaheb Ambedkar, the chairman of the adopting committee, is widely considered to be the architect of the Constitution of India. After adoption of the Constitution, Union of India became the contemporary and modern Republic of India. Now coming to the certain amendments of the Constitution of India. The Indian Constitution is not a rigid constitution. It came to be amended by the Parliament following few rules. There have been made many changes in the Constitution of India. Some important amendments of the Indian Constitutions are 42nd Amendment and 44th Amendment. The 42nd Amendment is also known as Mini Constitution because it made several sweeping changes to the Constitution. This was during the emergency in 1976. In 1973, the Supreme Court had ruled in the Keshwanand Bharati's case that constitution power of the Parliament under Article 368 does not empower it to alter the basic structure of the Constitution. Now coming to the preamble, what the preamble says, we the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic, republic, and to secure to all its citizens justice, social, economic, and political, liberty of thoughts, expression, belief, faith, and worship, equality of status and opportunity, and to promote among them all fraternity, assuring the dignity of the individuals and the unity and integrity. Now, the features of the constitutions are, the salient features of the Indian Constitution are listed below. The Indian Constitution is the lengthiest and it is a written constitution. Constitutions are classified into written like American Constitution or unwritten like a British Constitution. Constitution of India has the distinction of being the lengthiest and detailed constitutional document the world has so far produced. In other words, Constitution of India is the lengthiest of all the written constitution of the world. It is very comprehensive, elaborate and detailed document drawn from various sources. The Constitution of India has borrowed most of its provisions from the Constitution of various other countries as well as from the Government of India Act 1935. Near about 250 provisions of the 1935 Acts have been included in the Constitution. Dr. B.R. Ambedkar proudly acclaimed that the Constitution of India has been framed after ransacking all the known constitutions of the world. The structural part of the Constitution is to a large extent derived from the Government of India Act of 1935. The philosophical part of the Constitution, that is fundamental rights and directive principle of the state policy, derives their inspiration from American and Irish Constitution respectively. The political part of the Constitution, that is the principle of cabinet government and the relation between executive and the legislature, have been largely drawn from the British Constitution. Blends and rigidity and flexibility, that is as follows. The constitutions are classified into rigid and flexible. Rigid constitution is one that requires a special procedure for its amendment, as for example, the American Constitution is not easily amendable. Flexible constitution is one that can be amended in the same manner as the ordinary law are made, for example, British Constitution. The Indian Constitution is unique example of the combination of rigidity and flexibility. A constitution may be called rigid or flexible on the basis of its amending procedure. The Indian Constitution provides for three types of amendments ranging from simple to most difficult procedure depending on the nature of the amendment. Now coming to the federal system and unitary bias. It includes the Constitution of India establishes a federal system of government. It contains all the usual features of federalism, such as two governments, division of powers, written constitution, the supremacy of constitution, the rigidity of a constitution, independent judiciary, and bicameralism. However, Indian Constitution also contains large number of unitary and non-federal features, such as strong center, single constitution, appointment of state governor by the center, all India services, integrated judiciary, and so on. Moreover, the term federation has nowhere been used in the Constitution. Article 1 describes India as a union of states, which implies two things. Indian Federation is not the result of an agreement by the states, and no state has the right to secede from the federation. Hence, the Indian Constitution has been variously described as a federal in a form but unitary in spirit. Quasi-federal, that K.C. Ware says. The quasi-federal, I do not agree with the K.C. Ware. Parliamentary form of government, which means the Constitution of India has opted for a British parliamentary system of government rather than American presidential system of government. The parliamentary system is based on principle of cooperation and coordination between the legislative and executive organs, while the presidential system is based on doctrine of separation of powers between two organs. To read more about the difference between presidential and parliamentary form of government, check the linked article. The parliamentary system is also known as the Westminster model of government, responsible government, and cabinet government. The Constitution establishes the parliamentary system not only at the center but also in a state. In